contribution to this part.
Jacinda Ardern.
Thank you, Mr Chair. I want to thank the Minister for his contribution. I note, though, that he didn't speak specifically to the amendment around the issue of disabled children. I'd be interested in hearing his views on that particular amendment. I think the point still stands there, as I think the point still stands around the issue of those dependent children who might be in study, but for the purposes of this bill will affect the eligibility of their parent for a living alone payment if they're over the age of 18. And in spite of what the Minister has said, it seems to me that this has been an issue in the past. If you read the regulatory impact statement, there is some discussion in that statement, which of course was prepared by the Ministry of Social Development, which says that for the purposes of determining eligibility to the Social Security benefits, Section 63A of the Social Security Act sets out the circumstances in which a child aged 18 years or over is considered to be a dependent child. Our analysis has identified issues with the consistency of this definition across Social Security legislation. It goes on to talk about a specific case, Mr Chair, where this has been an issue. A recent decision by the Social Security Appeal Authority, decision number 38/09, has highlighted an inconsistency between the definitions of a dependent child as it applies to a child aged 18 years or over. The decision found that an adult child, i.e. over the age of 18 years, who is maintained as a member of a superannuitant's family and is not financially independent, may be categorised as a dependent child for the purposes of eligibility for the living alone payment. There has already been a case which has highlighted that this can indeed be an issue, and that according to the Social Security Appeal Authority, that needs to come down on the side of the entitlement remaining, because the fact that that adult child can still be considered a dependent child because of their circumstances. There is some further clarification, though, admittedly, and we concede this point. This will not apply to a large number of parents and their children, but it does clarify that it says the Ministry is of the view that it is unlikely many other cases will arise, as the situation applies only to superannuitants living with a student with no income other than a student loan, but not a student allowance. And this has been our point, that there will be students who will not be eligible for a student allowance. They may access a student loan, but they may be living with someone who is eligible for a living alone payment. But because they are over the age of 18, the crude definition in the bill means that that living alone payment could be affected by that. Now, no one's arguing that this is going to be a really prevalent situation, but what we are arguing is that it could occur and that it would be wrong if it did. And the regulatory impact statement admits that. Now, there is some admission in here that there is some discretion for the Chief Executive to continue paying the rate until the payday immediately after 31 December in the year that the child reaches 18 years. But we shouldn't ever allow these things just to be determined by discretion when we know the issue exists and we have the ability within primary legislation to fix it. So this is something that we're asking the Minister to fix. We're at a point now where we can. We have evidence that it has arisen before. Why should we have to require people to go via an appeal authority to have it addressed? So I'd like the Minister's thoughts on that, but I equally really would also like to hear his views on the definition of dependent child as it applies to a child that may have an intellectual disability, because equally we feel that that particular issue has gone unanswered.
The question is that the Minister's amendment set out on SOP number 191 be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. We move to the amendments in Jacinda Ardern's name. And the first one is an amendment to new section 4A4B relating to a child with intellectual disability. The question is that the amendment be agreed to. Those of that opinion will say aye. Contrary, no. Noes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party.
14 votes in favour.
New Zealand First.
7 votes in favour.
Māori Party.
3 votes opposed.
I have to take it from
The Maori Party is represented.
Mr. Chairman, I have spoken to the co-leader of the Maori Party, who's authorised me to vote for him, though he's in the House this morning.
Unfortunately, standing orders say if the party is present, they have to vote. So,
3 votes opposed.
How many was it?
3. 3?
Yes.
Yes.
Mana.
Vote in favour.
Act New Zealand.
1 opposed.
United Future.
1 opposed.
Brendan Horan.
1 in favour.
The ayes 57, the noes 64. The amendment is not agreed to. We move now to Jacinda Ardern's second amendment to new section 4A, 4B to replace 18 with 25. The question is that the amendment be agreed to. Those of that opinion will say aye. Contrary, no. Noes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party.
14 votes in favour.
New Zealand First.
7 votes in favour.
Māori Party.
3 votes opposed.
Mana.
1 vote in favour.
Act New Zealand.
1 opposed.
United Future.
1 opposed.
Brendan Horan.
1 in favour.
The ayes are 57, the noes 64. The amendment is not agreed to. We move now to Jacinda Ardern's amendment to new paragraph 4A, 4C. The question is the amendment be agreed to. Those of that opinion will say aye. Contrary, no. Noes have it. Party vote. The clerk will conduct a party vote.
New Zealand National.
59 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party.
14 votes in favour.
New Zealand First.
7 votes in favour.
Māori Party.
3 votes opposed.
Mana.
1 vote in favour.
Act New Zealand.
1 opposed.
United Future.
1 opposed.
Brendan Horan.
1 in favour.
Ayes are 57, noes are 64. The amendment is not agreed to. The question now is that Part 1, as amended, stand part. Those of that opinion will say aye. Contrary, no. The ayes have it. The question, point of order.
I didn't hear, I'm sorry, what that question was, and would you mind repeating what the question?
Well, it's been carried that Part 1, as amended, stand part, and it's now been agreed.
The reason for my confusion was that I thought that there were more amendments than, in fact, there were votes taken.
I think I enunciated it quite clearly. It's been passed unanimously, and we move to Part 2. So the question is that Part 2